Rules under the No-Fault Indemnity Clause. 1. The total indemnity in respect of any one person shall not exceed P15,000 for all motor vehicles, INS. Memo. Circ No. April 2006. 2. Proof of loss. A. Police report of accident. B. Death certificate and evidence sufficient to establish proper pay. C. Medical report and evidence of medical or hospital disbursement. 3. Claim may be made against one motor vehicle only. 4. In case injury of an occupant of a vehicle, the claim shall lie against the insurer of the vehicle in which the occupant is riding, mounting or dismounting from. 5. In any other case, claim shall lie against the insurer of the directly offending vehicle. 6. In all cases, the right of the party paying the claim to recover against the owner of the vehicle responsible for the accident shall be maintained. The claimant is not free to choose from which insurer he will claim the no-fault indemnity, as the law, by using the word shall, makes it mandatory that the claim be made against the insurer of the vehicle in which the occupant is riding, mounting or dismounting from. That said vehicle might not be the one that caused the accident is of no moment, since the law itself provides that the party paying may recover against the owner of the vehicle responsible for the accident. This no-fault claim does not apply to property damage. If the total indemnity claim exceeds P15,000 and there is controversy in respect thereto, the finding of fault may be availed of by the insurer only as to the excess. The first P15,000 shall be paid without regard to the fault. Q. X is a passenger of a jeepney for hire being driven by Y. The jeepney collided with another passenger jeepney being driven by Z, who was driving recklessly. As a result of the collision, X suffered injuries. Both passenger jeepneys are covered by comprehensive motor vehicular insurance coverage. If X wants to claim under the no-fault indemnity clause, his claim will lie a. against the insurer of the passenger jeepney driven by Y because X was his passenger. The insurance code states that in the case of an occupant of a vehicle, the claim shall lie against the insurer of the vehicle in which the occupant is riding, mounting or dismounting from. Authorized driver clause. It indemnifies the insured owner against loss or damage to the car but limits the use of the insured vehicle to 1. The insured himself, or the insured need not prove that he has a driver's license at the time of the accident if he was the driver. 2. Any person who drives on his order or with his permission, provided that the person driving is permitted to drive the motor vehicle in accordance with the law, and is not disqualified. Villacorta v. Insurance Commissioner, Gr. No. 54171, October 28, 1980. The main purpose of this clause is to require a person other than the insured, who drives the car on the insured's order or with his permission, to be duly licensed drivers and have no disqualification to drive a motor vehicle. An Irish citizen whose 90-day tourist visa had expired, cannot recover on his car insurance policy, not being authorized to drive a motor vehicle without a Philippine driver's license. Stokes v. Malayan Insurance Co., Inc. Gr. No. L. 34768, February 24, 1984. A driver with an expired traffic violation receipt or expired temporary operator's permit is not considered an authorized driver within the meaning of the insurance policy. The traffic violation receipt is coterminous with a confiscated license under the motor vehicle law, Gutierrez v. Capital Insurance and Surety Co., Inc., Gr. No. L. 26287, June 29, 1984. Theft. It is that which includes theft as among the risks insured against. Where a car is unlawfully and wrongfully taken without the knowledge and consent of the owner, such taking constitutes theft. And it is the theft clause, not the authorized driver clause, which should apply. The theft clause of a comprehensive motor vehicle insurance policy has been interpreted by the court in several cases to cover situations like when one takes the motor vehicle of another without the latter's consent, even if the motor vehicle is later returned. There is theft, there being intent to gain, as the use of the thing unlawfully taken constitutes gain, or when there is taking of a vehicle by another person without the permission or authority from the owner thereof, paramount. Insurance vs Spouses Remanja Ulaz, GR number 173773, November 28, 2012. Theft. There is theft if the vehicle is taken with intent to gain without the consent of the insured owner. Thus, there is theft even if 1. The vehicle is returned, 2. The vehicle was stolen by the driver of the insured, Alpha Insurance and Surety Company v. Castor, GR 198174, September 2, 2013, 3. The vehicle was taken to the owner of a repair shop for the purpose of repair and in order to attach accessories, Paramount Insurance v. Spouses Remanja Ulaz, GR number 173773, November 28, 2012. Q. On May 26, 2014, Jess insured with Jack Insurance his 2014 Toyota Corolla sedan under a comprehensive motor vehicle insurance policy for 1 year. On July 1, 2014, Jess' car was unlawfully taken. Hence, he immediately reported the theft to the Traffic Management Command of the Philippine National Police, which made Jess accomplish a complaint sheet as part of its procedure. In the complaint sheet, Jess alleged that a certain Rick Silat took possession of the subject vehicle to add accessories and improvements thereon. However, Silat failed to return the subject vehicle within the agreed 3-day period. As a result, Jess notified Jack of his claim for reimbursement of the value of the lost vehicle under the insurance policy. Jack refused to pay, claiming that there is no theft as Jess gave Silat lawful possession of the car. Is Jack correct? A. No, Jack Insurance is not correct. Rick Silat was merely given physical possession of the car. He did not have juridical possession over the same. It is also apparent that the taking by Silat of the car of Jess is without the consent or authority of the latter. Thus, the act of Silat in depriving Jess of his car, soon after the transfer of physical possession of the same to him, constitutes theft under the insurance policy that is compensable, Paramount Insurance v. Spouses Remondulaz, GR number 173773, November 8, 2012. Q. On February 21, 2013, Barrick entered into a contract of insurance with Matino Insurance Company involving a motor vehicle. The policy obligates Matino to pay Barrick the amount of P600,000 in case of loss or damage to said vehicle during the period covered, which is from February 26, 2013 to February 26, 2014. On April 16, 2013, at about 9 a.m., Barrick instructed his driver, JJ, to bring the motor vehicle to a nearby auto shop for tune-up. However, JJ no longer, despite and diligent efforts to locate the said vehicle, the efforts proved futile. Resultantly, Barrick promptly notified Matino of the said loss and demanded payment of the insurance proceeds of P600,000. In a letter dated July 5, 2013, Matino denied the claim, reasoning as stated in the contract that the company shall not be liable for any malicious damage caused by the insured, any member of his family, or by a person in the insured's service. Is Matino correct in denying the claim? A. Matino Insurance is not correct in denying the claim. The loss of the motor vehicle is not excluded under the insurance policy, as the loss was due to theft, not malicious damage. The malicious damage clause under the policy is not applicable, but rather the theft clause. Thus, the provision under the policy that the company shall not be liable for any malicious damage caused by the insured. Any member of his family or by a person in the insured's service is not applicable. Q. When a passenger jeepney, insured but with an authorized driver's clause and was driven by a driver who only holds a traffic violation report because his license was confiscated, met an accident. May the owner of the jeepney claim from the insurance company? A. Yes. The fact that the driver was merely holding a TVR does not violate the condition that the driver should have a valid and existing driver's license. Besides, such a condition should be disregarded because what is involved is a passenger jeepney. And what is involved here is not own damage insurance but third-party liability where the injured party is a third party not privy to the contract of insurance. Insurable interest. An insurable interest is that interest which a person is deemed to have in the subject matter insured, where he has a relation or connection with or concern in it, such that the person will derive pecuniary benefit or advantage from the preservation of the subject matter insured and will suffer pecuniary loss or damage from its destruction, termination, or injury by the happening of the event insured against. Note: the existence of insurable interest is a matter of public policy and is not susceptible to the principle of estoppel. The existence of an insurable interest gives a person the legal right to insure the subject matter of the policy of insurance. Violetta R. Lalakan vs. The Insular Life Assurance Co. Ltd., Gr. No. 183526, August 25, 2009. Mere hope or expectancy is not insurable. A mere contingent or expectant interest in anything, not founded on an actual right to the thing, nor upon any valid contract for it, is not insurable. ICC, Seconds. 16. When does a person have insurable interest? Gr. A person is deemed to have an insurable interest in the subject matter insured when a person has a relation or connection with or concern in the subject matter, such that he will derive pecuniary benefit or advantage from its preservation and will suffer pecuniary loss from its destruction or injury by the happening of the event insured against. However, in some cases, expectation of benefit from the continued life of that person need not necessarily be of pecuniary nature to have an insurable interest in the life of a person. Q. Carlo and Bianca met in the La Boracay festivities. Immediately, they fell in love with each other and got married soon after. They have been cohabiting blissfully as husband and wife, but they did not have any offspring. As the years passed by, Carlo decided to take out insurance on Bianca's life for $1 million with him as sole beneficiary, given that he did not have a steady source of income and he always depended on Bianca both emotionally and financially. During the term of the insurance, Bianca died of what appeared to be a mysterious cause, so that which led Carlo to immediately requested for an autopsy to be conducted. It was established that Bianca was transgender all along, a fact unknown to Carlo. Can Carlo claim the insurance benefit? A. Yes, Carlo can claim the insurance benefit. He had insurable interest on Bianca's life under Section 10 of the Insurance Code, as the problem states that Carlo always depended on Bianca both emotionally and financially. The insurable interest upon the life of another under the aforesaid provision need not be based on kinship or legal obligation to give support. The fact that their marriage may be void is irrelevant.